turned a single person down. The worst of charges didn't matter, he showed up in that town. They asked him how he stood beside the ones accused. He said it's not about the outcome, it's a fair process for the truth. Didn't matter rich or poor or what they'd done, he believed the Constitution covered everyone. Justice is a process, not a verdict, not a deal. Every single courtroom make them prove that what they feel. We don't look away, we don't let them close the door. Shopping paperwork, he kept on teaching constitutional rights that they said he shouldn't be preaching. 12 years old, I sat behind my father, watched the system try to break the only man that mattered. He said the law belongs to everyone who needs it, not just the ones with power, money, those who seized it. Justice is a process, not a verdict, not a deal. Every single courtroom make them prove that what they feel. We don't look away, we don't let him close the door. This is what he built us for. Justice is a process, and we'll watch it, and we'll watch it. They convicted him for caring, for teaching from a coffee shop. They feared the world he built, but the world he built won't stop. Justice is a process, not a verdict, not a deal. Every single courtroom make them prove that what they feel. We don't look away, we don't let them close the door. This is what he built us for. Justice, and we'll watch it every single We'll watch it. Justice is a
Welcome to the studio show with Justice is a Process. I'm Steve. I'm the host here of Justice is a Process. And we are going to be discussing tonight, the Edrick Faust case, which might be one of the biggest injustices I've seen in a very, very long time. But we're going to get into it. We're going to break down what happened in this case, and I'm going to give you my take on exactly what I think went wrong here, how, and my reaction to the verdict, because this is, I think something very wrong went down in Georgia in this case, and it's very disturbing, because justice is a process, and for Mr. Faust, that means that it will go on. But I think this was literally when my father and I created this channel, this is the exact kind of case that we were talking about when we would say the outcome is not what we're here for. We're here for a fair process. And we can say without a shadow of a doubt that this case did not have a fair process. The judge, the prosecutors, you saw, what you saw in this case is if the law would have been followed, this verdict should have been not guilty, 100%. And I'm going to explain that to you. We're going to get into it on why that is, unequivocally. But what you saw was a judge, a prosecutor who were striving for an outcome, and they bent over backwards to get that outcome, and they maneuvered the jury in the direction of that outcome. And with potentially grave results for Mr. Faust. Because I think we genuinely have a man here who is innocent. I'm not going to say who did it because I don't know who did it. I think there's some of us who can suspect who did it. There was an individual who took the stand. But I'm not here to accuse anybody. I'm here to analyze the Faust case and what I saw, what I watched, and the absolute sadness I feel when I see the justice system go off the rails like it did in this case. And there's some of you out there that don't agree with that, and that's okay. And you're welcome to come in this comment section if you see this and check it out, but and leave your thoughts, because I welcome that. I welcome your perspective. But as someone who has watched hundreds of cases, who's been around the justice system from infancy, I can tell you that this case, there is something very, very wrong with the outcome here. And based on the law, Mr. Faust should have been found not guilty. But other things were happening in this case that led to an outcome that, unfortunately, like I said, this was an outcome that the prosecutor and the judge bent over backwards to try to make happen. And unfortunately, Mr. Faust's attorney, in my opinion, although he was a zealous advocate and a fighter, he himself also made some mistakes. And I think when you get emotionally involved in a case, sometimes you get tunnel vision, or you miss things, or things happen, and you don't end up making the moves that you should have, or perhaps it was inexperienced. Because one thing I will say is that Mr. Faust's attorney, although a zealous advocate with a tremendous amount of zeal and fight, he lacked the experience against the judge and the prosecutor that the judge and the prosecutor had. And they ran circles around him, and they walked him down the lane. They gutted his case. And in my opinion, it was an absolutely disgusting display that we should all be disturbed by, and we should all demand better than what we saw go on in that courtroom. And Judge Lott and Mr. Yamacelli, those two people should absolutely embolden, they should hang their head in shame for what they did in that courtroom, because that was not justice. That was a focus on an outcome. That was not a focus on a fair process. Anyways, with that said, guys, we're going to jump into this here. Now, I'm going to introduce you to something that my members, if you're paying attention, have had access to, and they have access to it currently on all the cases we have: Corey Richens, the Dale Warner case, the Gray case, all of these in past cases. And it is our case notebook powered by Justice AI and partnered with Notebook LM. And we're going to get into it. I'm going to show you what you have here, because this is something that, if you're a member, you can actually come in and interact with the case, chat with the case, talk with the justice the AI version of justice. But I'm going to show you. We're going to go through some things, and we're going to let Justice AI. We're going to actually hear the Justice AI two-host debate. One's going to take the prosecution, one's going to take the defense. We're going to listen to it, we're going to react to it, and we're going to talk about some things. And I'm going to give you my thoughts on exactly what happened here and how Mr. Faust ended up in the situation he did. Without further ado, let's jump into Justice AI here. So welcome to Justice AI. And here it is. This is essentially a case notebook. And as you're going to see, all of the, there's three sections to it. You've got on the left-hand side sources, and all the sources that we utilize in Justice AI, or that are basically fueling the chatbot in here. And it's got every piece of content that goes into this notebook. Our source material that we use for our pre-case research is in here. Every article that we write on the website is in here. You get to interact with it, talk with it, and the entire trial transcript is contained in this notebook. So you want to know something, you want to know about DNA, you want to know what happened on day 1, day 2, day 3. It's right here. Now, all you have to do in order to have access to this is be a member. And that's it's every level of membership gets access to this. And you can go to either the member page where you will see the post, or if you want to make it easy, go into the Justice as a Process website, find the case, and in the case coverage area, you will see a link that will get you to a that will take you to a post that explains how to use this. Click the link and you're in. And like I said, this is updated throughout the case. This is built throughout the case. And there are various different little things that we provide provide the notebook with. So, for instance, if you look over here, this is where we're going to get into. I will produce various different presentations, slideshows, things of that nature. But what we're going to be listening to tonight, and we're going to be watching tonight, is going to be the debate, and it's called 800 quadrillion DNA.
People saw a window of opportunity and took. Welcome to the debate. 1 in 800 quadrillion. That is the number that ended a 23-year wait for justice in Athens, Georgia. Today, we are dissecting Georgia v. Faust, the conviction of Edrick Faust for the brutal 2001 murder of law student Tara Baker.
Right, and we are asking if that number, as impressive as it sounds, blinded the jury to a reality that was far messier. Did the jury get it right? Or was this conviction a case of tunnel vision, where modern science was used to basically bulldoze over a mountain of physical evidence that pointed squarely at someone else?
I mean, this case is a masterclass in the evolution of forensics. You have a cold case, a law student killed in her home, and for 2 decades, absolutely nothing. Then, the Georgia Bureau of Investigations utilizes true allele probabilistic genotyping, which is a method that can untangle mixed DNA profiles that old science just couldn't touch. And it pointed to one man, Edrick Faust. I am here to argue that the system worked. Science caught a killer that human investigators missed for a generation.
And I'm here to argue that science isn't a magic wand you can just wave to make contradictory evidence disappear. I'm representing the position that reasonable doubt was overwhelmed by a single statistic. The investigation involved coaching an alternative suspect to explain away his own DNA found inside the victim, ignoring the fact that the killer left 0 physical trace in the home, and frankly rushing the case due to media pressure while disregarding forensic evidence like hair in the victim's hand that explicitly pointed to a Caucasian perpetrator, not Edrick Faust.
Well, let's establish the baseline first. For 23 years, the Tara Baker murder was this open wound for Athens. But in 2024, the GBI re-examined the sexual assault kit. The results were not ambiguous. They found a match to Edrick Faust. We aren't talking about a low-level probability or a partial profile here. The match frequency was 1 in 800 quadrillion. And then the true allele analysis.
All right, so let's talk about this for a moment here and what you're hearing. So what we set up here, and again, these are presentations. Every case will have these. I can add these to the Justice AI notebook and the case notebook. But what we have here is two advocates. One is going to be arguing, so you understand what we're listening to. One will be arguing for the that Faust outcome was correct. One's going to be arguing for the defense. And we're going to talk about it and react to it. But this is the number right here that drove this case, as you can see up on the screen. 1 in 800 quadrillion. The source for this was an oral swab. The method of use was true allele analysis, and it was, like I said, astronomical. But there's something important that I want you to understand as you're listening to this, and I want you to keep it in mind, because this is something that was lost track of in the trial. Everyone said his DNA was found in her mouth. And this is an extremely important distinction. And my dad was actually one of the first defense attorneys to ever use DNA or be a part of a case that was part of DNA in the country. It's one of the reasons why when the O.J. Simpson case happened, he was consulted by the O.J. Simpson defense team, because he was one of the first lawyers to ever have to defend against DNA. But one of the things my dad used to impart with me when we would bring up DNA, and I remember talking about it with the O.J. case, and that is that the DNA is on the swab. It's not in her mouth. It's supposed to have come from her mouth. Part of the process that the prosecution is obligated to show is that what was tested on that swab came from her mouth. And that's what you call chain of custody. So the prosecution in this case needed to prove that the DNA that was on that swab came only from her mouth, or was taken from her mouth. And one of the issues when you get into the true allele analysis, it's why it's controversial, is it's highly, highly, highly sensitive, meaning it has a potential to pick up contamination. And one of the key pillars in this case that everyone must understand is, because you would say, well, okay, contamination, well, how would Edrick Faust DNA have gotten to that lab? Edrick Faust committed a crime 2 weeks after Tara Baker's death. And it's significant because her DNA swabs, her evidence was in that same lab as the evidence that came in for that case. Evidence that would have had Edrick Faust DNA. It would have been in the same lab, in the same place where hairs got lost, envelopes got opened, slides got broken. And as we learned in the O.J. Simpson case, contamination, especially because in the O.J. Simpson case, one thing people don't really understand is they used something called PCR testing, which was very, very new at the time. The same thing that they used when they were doing all of the testing for a certain virus that swept the nation a few years ago. And one of the cautions against using that was it was highly, 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 highly potentially susceptible to contamination. And it would pick up on things that if everything wasn't perfect, if the conditions weren't perfect, you could easily contaminate, and it would pick up stuff that normal DNA tests would not. And that's what happened here. And that's what I believe happened here. That you had literally a confluence of events in a perfect storm that led to a minute amount of Edrick Faust DNA ending up on the swabs and the samples. And then the rest took care of itself. And again, one thing that, as my dad imparted to me, is corroboration of the DNA. DNA should never stand alone as a convictor, even though CSI and everything has suggested that it should. You need to, first of all, verify chain of custody. You need to make sure there's no potential contamination issues. And then you need to look at the testing. You need to look at how everything was done. And then on top of that, you need other evidence to corroborate it. Now, in a case like this, where there really truly was no other evidence, and there was only a small, minute amount of DNA, and then you have the circumstances of how the DNA could have gotten contaminated, that in and of itself is reasonable doubt. There's a couple problems, though. The jury never learned about that. One, because it was excluded due to 403 and 404B motions that said that it would be that was past character evidence that shouldn't have come in, and as a result, the judge excluded it, and the defense requested it because the defense was in a rock and a hard place. Either let the jury know that Mr. Faust had stabbed someone in the neck 2 weeks after this crime, which could potentially in and of itself lead the jury to believe to convict, or don't talk about that and then leave the jury with the impression of how did the DNA get there, and that makes no sense. Either way, boxed in the defense in a way, in my opinion, the defense should have put that evidence in. They should have let Mr. Faust testify. It was the box that they were put in, and they should have embraced it and said, look, this is your explanation. And had they done that, I think they would have had a potential shot at Mr. Faust winning the case, although with the judge and everything that happened, it would have been still very difficult if he would have had to been subjected to the cross-examination for Gallim and Chile. But it would have given the explanation to the jury for how it got there, and it would have helped them see that this is it. This is all you have, is DNA, a minute amount of DNA that has ended up on a sample that had, and again, one of the hallmarks of contamination is when there's multiple types of DNA, and every single one of these samples, as you will see, had multiple in unidentified DNA on it, meaning that's a sign that that the DNA or that these samples in these swabs were contaminated. And if they were contaminated, you can't trust them. And if you can't trust them, then you can't rely on them. And if the only thing sitting there are those swabs, you got nothing. And then on the fact that it's a circumstantial case where the law is clear on circumstantial cases, that if you don't eliminate each and every potential possibility of innocence, then you can't convict at all. And Chris Melton was still alive, still sitting there as a potential possibility. His DNA was found in places that it shouldn't have been. His DNA was found. His DNA was found in a time frame where it should not have been. That it didn't make sense. The jury should have thrown this case out and said, well, we're not convicting. Anyways, I'm jumping ahead here, but I wanted to jump in on that. So let's resume with our host and listen to what they have to say. And like I said, I'll jump in from time to time to share my thoughts.
Analysis of the oral swabs, the likelihood was 30 octillion.
You're leading with the zeros.
Because they matter.
It's a powerful rhetorical strategy, sure, and it obviously worked on the jury, but let's strip the zeros away and look at the actual biology and the context.
It represents identity, period. Edrick Faust's biological material was found inside the body of a woman he claimed he never met, never knew, and had never even seen. Combine that with the geography, right? Faust lived at 350 Cooper Road. That is literally 585 feet from Tara Baker's front door. You have a neighbor with a history of violence, a stranger to the victim, committing a crime of opportunity. It is the Occam's razor conclusion.
If we are applying Occam's razor, we have to look at the entirety of the evidence, not just the molecule that fits the state's theory. You mentioned the biological material. Let's be precise. Faust's DNA was found. But where was it found? In the oral and vaginal swabs. But here is the summary of the physical scene. Tara Baker fought for her life. She was stabbed, beaten, strangled. She was found with hair clutched in her left hand, a classic defensive posture. That hair, Caucasian. The hair found on her torso, Caucasian. The hair entangled in the ligature, the actual weapon used to kill her, Caucasian.
Right. But the state's expert, Larry Peterson, addressed this directly. He testified that finding a victim's own hair in their hands is statistically very common in head trauma cases. She was brutally beaten. She likely grabbed her own head in pain or confusion.
That is a plausible theory, if you completely ignore the suspect's physiology. Edrick Faust had a significant afro at the time. We're talking about a violent, close-quarter struggle in a very small room. Yet not a single African-American hair was found on the victim, on the weapon, or anywhere in the house. And crucially, Faust left no fingerprints, no footprints, and no other DNA in the home. The state conceded they don't even know how he entered the house.
All right, so let's talk about that for a moment, guys, because I think that is one of, in my opinion, one of the strongest points here. And that is, Edrick Faust, at the time of this crime, had a afro, or a small afro. He enters this house. He gets into a struggle with this individual. He allegedly stabs her, does other things to her of a sexual nature. He burns the house down. He cleans up the place, and he leaves not one hair. He leaves not one trace. The only trace that is found of Edrick Faust is on a swab that allegedly came from her mouth. I repeat, a swab that came from her mouth and her vaginal area. That is where, and again, I emphasize that, it was not found in her house. It was not found in her body. It was found on a swab that was said to have come from there. That was in a lab that we know, by all practical purposes, for all practical purposes, was a mess and did not follow protocols. And their protocols were so bad that evidence was lost, that evidence was broken, and that evidence was for absolutely potentially contaminated. And it is the same lab that 2 weeks after the crime against Tara Baker that Edrick Faust commits another crime and his biological materials passing through that lab. And that is significant. And of course, the jury didn't learn about that. And they didn't know about that. And they weren't allowed to. And that was a strategic move by the defense. The defense made that request. But by them not knowing about that, they had no explanation for how this happened, for how the material could have gotten. And further, they were further blocked out because there's another way it could have come, is that same lab, which is reopening samples and looking at these samples throughout the years, ends up having Edrick Faust DNA come back through the lab to be registered with CODIS. So here we have a lab that has terrible protocols, that has, again, on these samples themselves, there are still unidentified DNA on these samples, which is the #1 hallmark and predictor that contamination has occurred. And the jury thinks that they found his DNA in a database, an external database, because once again, the defense fights hard to say we don't want CODIS, when they should have been saying we have to let them know. It's the only way you can explain the DNA's presence. So again, they were backed into a box. And yes, this is one of those scenarios where the defendant's going to have to get on the stand. And the defendant is going to have to explain this. And the defendant is going to have to explain so that you can then put on the stand and you can then put in a record exactly how the DNA could have potentially arrived. And you can argue that to the jury. And they needed to call a DNA expert who could have testified to how true allele works and to the sensitivity of these tests. And they could have said, yes, these are very subjective. They should have had someone coming in and reviewing the practices of this lab. And they should have said, hey, come in and look at this and discuss it and discuss the potential that the way this was processed and the way this was handled and the fact that these were being processed based on standards from 24 years ago, before true allele ever existed, that the probability of contamination is extremely high. And the greatest evidence of that is all of the unknown DNA that were found on these swabs. And then they should have argued that we did not find Tara Baker's DNA in her mouth, or Edrick Faust's DNA in her mouth. It was found on a swab that was alleged to have come from her mouth. And due to the way these swabs were collected, we really don't know what actually came from her mouth. And when it would have been put that way, this case goes away, bye-bye. Instead, what we got was what I thought was one of the biggest blunders of the case, was an opening statement that says, we're not here to talk about DNA. And yes, that was the defense saying that. And that was the start of the problems. Because yes, that is the only thing that you're here to talk about. Because it's the only thing that links Edrick Faust to this case. Anyways, with that said, we're going to get back to the presentation. But, you know, this is unbelievable stuff, guys. And it's very, very frustrating.
You basically have a ghost killer who leaves only the specific DNA evidence the prosecution needs and literally nothing else.
Complete narrative arc of entry and exit, because soft evidence degrades over 2 decades. But the absence of fingerprints does not negate the presence of cellular DNA inside the victim. You cannot fake that. And regarding the other DNA present, because I know we need to address the boyfriend Chris Melton, the prosecution provided a logical, scientifically sound explanation. Yes, Melton's DNA was present, but they were in an ongoing relationship.
President is doing a lot of heavy lifting there. This brings us to the technical core of the debate, really, the battle of the DNA. Chris Melton's DNA was found in the victim's anus. This is the anatomical site of the aggravated sodomy charge. Melton's DNA was a match at 60,000 times more probable than a random person. Now, context matters. Melton claimed he had not seen Tara for 10 days prior to the murder.
He initially said 10 days, yes. He later clarified they were on the outs and it might have been closer to 5 days.
He clarified it after being coached by police, but let's just stick to the science for a second. The defense introduced peer-reviewed studies, and even the state's own expert, Ashley Hinkle, had to acknowledge this. Anal DNA degrades rapidly, We are talking a maximum of 2 to 3 days for detection in that specific environment. If Melton's timeline is true, that he hadn't seen her in nearly a week, his DNA scientific charges, contrasting the legal weight of Melton's unrefuted anal DNA against Faust's DNA in the mouth, is a massive hurdle for the state.
The prosecution explained this through the drainage theory, and this isn't just a guess. Dr. Falzin, the medical examiner, testified about the body's position. She was face down, hips elevated. Gravity and decomposition cause fluids to migrate. It is grim, I know, but biological material from the vagina, where Melton's DNA would persist longer due to their relationship, could migrate to the anal cavity post-mortem. It creates a bridge between the timeline and the forensic reality.
It creates a convenient patch for a massive hole in the case, is what it does. Drainage is a theoretical possibility, sure, but look at how the investigation handled the suspect himself. When they found Melton's DNA in the sodomy profile, did they treat him as a suspect? No. We heard the recording of Agent Elizabeth Bigham interviewing Melton in 2024. She didn't interrogate him, she told him explicitly, "I need you to help me explain away your DNA." She told him she needed to separate Chris Melton's DNA from the bad guy's DNA. That is confirmation bias in its purest form. They weren't following the evidence, they were curating it to fit Faust. The defense rightly argued that media pressure forced investigators to rush this to wrap up Athens' biggest cold case neatly.
I completely disagree with the word curating. Agent Bigham was conducting a cold case review. She had a cold hit on Faust, a stranger with a rap sheet living 500 feet away. She has to clear the boyfriend to build the case against the most likely perpetrator. And we really have to talk about the reclassification of the swabs, because the defense treated this like some grand conspiracy, but it's actually just correcting a clerical error.
A clerical error discovered 23 years later that just happens to perfectly save the state's timeline. You have a swab labeled oral for 2 decades. Suddenly, because the timeline doesn't work for the boyfriend, a private lab in California, Pure Gold Forensics, uses a presumptive test to say
Dictates the conclusion, not the label on the envelope. Pure Gold Forensics detected vaginal epithelial cells on the swab labeled oral. The medical examiner mislabeled a tube 20 years ago. When you correct that label, the evidence aligns. Faust assaulted her orally where his DNA was found, and Melton's presence is explained by prior consent.
Okay, so again, I got to jump in here. So this is very, very important to understand, and I hope everyone fully understands what happened in the trial on this point. Because what happened here is we had essentially the prosecution, and again, I think it's important to understand this in the vacuum of looking at this, and we're going to move forward here to help me explain it away. When you have an investigator who is essentially saying, we need to explain away your DNA, separate Chris Melton from the bad guy. The investigator is choosing, she's not following evidence. She's choosing who to apply the evidence to. And that's an important distinction. Because what ends up happening is it doesn't just happen here. We see it happen here on tape in the interrogation room. But then a decision is made to decide that one of these is going to be decided that there's multiple oral swabs, and one of those has to become a vaginal swab. And that is the only way this case is going to work, and that they can move forward with prosecuting Edrick Faust. Because if the oral swab stays, it means that Melton undeniably dropped that DNA or deposited that DNA within 48 hours of the crime, meaning he is as likely to have been there as Edrick Faust. So they send it away. And they send it away to Pure Gold Forensics, who makes the finding that they need, reclassifies that swab as the vaginal swab, and suddenly Chris Melton now has a 7-day window, to which Chris Melton then changes his story from 10 days to 5 days as to when he last had contact with Tara in a way that would have deposited that DNA, and suddenly they can prosecute the case. But when you look at this in the lens of everything that's happening here, that you have an investigator in live time deciding that One suspect is better than the other, even though one suspect has no connection to the case besides some DNA they found on a swab. Again, a swab that is supposed to have come from the victim's orifices 24 years before, collected under standards that were not at all aligned with the true allele standards that would have been done in a way to have guaranteed the contamination and that the results will be reliable. And with other third parties' DNA present on these swabs, that indicates that there's a high level of potential possibility for contamination. And at the same time, as I showed you, the contamination theory. And what is the contamination theory? January 19th, Tara Baker is killed. February 4th, Faust's arrest. There's blood samples taken. There's blood samples sent to the lab. And the question becomes then, was this cross-contamination? As these samples are being unsealed and tested, and again, remember, one other fact. When they looked at these swabs originally did not have any detectable DNA on it that was available for testing. That's why they weren't tested. It wasn't until 24 years later that they had to use a test that magnified the DNA to such a level that they could see. And again, that is exactly the conditions that lead to picking up cross-contamination instead of actual substances that came out of the body parts in areas that they're claiming it came from. They did not prove, and the state did not prove that came from her mouth. In fact, the chain of custody issues in this case were ignored by the judge. And the defense specifically said there are chain of custody issues. And they said, well, you can argue that to the jury. A jury who clearly didn't understand what that meant, who clearly didn't have all of the information in front of them, because the defense, of course, by the time the defense case came on, they didn't put on a defense case. So nobody was there from the defense side to interpret what any of that meant, what the chain of custody breakdowns meant, how that can impact the test results that they saw. And we had a defense attorney who very clearly says at the very beginning, we're not here to talk about DNA. And yet the jury was here to talk about DNA. And the prosecution was here to talk about DNA. And that's how we ended up here. And it's very, very sad for Mr. Edrick Faust. Anyways, let's resume the presentation here and continue listening to the great debate here.
Envelope. Pure Gold Forensics detected vaginal epithelial cells on the swab labeled oral. The medical examiner mislabeled a tube 20 years ago. When you correct that label, the evidence aligns. Faust assaulted her orally where his DNA was found, and Melton's presence is explained by prior consensual contact.
You say aligns, I say retroactively fitted. You are asking the jury to accept a chain of corrections that all miraculously favor the state. Correct the label, accept the drainage theory, ignore the degradation timeline. And while we are correcting things, we still haven't solved the locked room mystery.
You mean the entry point?
Exactly. The fire department had to kick. How did he leave a locked apartment behind him? How does the state's proximity argument override a fundamentally locked door?
Look, the state acknowledged they don't know the precise method of entry, but let's look at the alternative the defense proposed. They argued that the locked doors imply the boyfriend, Chris Melton, because he might have had a key. But Melton testified under oath he didn't have a key.
Melton also testified he went to a country concert instead of her vigil. His behavior was incredibly suspicious. But regarding the key, the defense argued this was an interpersonal relationship violence crime, not a stranger break-in. The lack of forced entry strongly supports someone the victim knew and opened the door for, or someone who had a key. Faust hadn't either.
But Faust lived 585 feet away. We cannot ignore the geography. In a crime of opportunity, a neighbor watching, seeing a young woman alone, that is a proximity that creates access. And regarding the window screen, there was evidence of tampering, a bent screen. It suggests an attempted entry. Just because we don't have a video of him climbing through the window doesn't mean he didn't do it. The DNA proves he was inside. How we got in this secondary to the fact that he was there.
Secondary is a very dangerous word when you're sending a man to prison for life. Let's pivot to what the jury didn't see, because this connects to the integrity of the evidence itself, the contamination theory. This was the defense's hidden argument that was excluded under Rule 403 and 404B.
Ah, you're referring to the incident 16 days later?
Yes. 16 days after Tara Baker was murdered, Edrick Faust committed a stabbing. He stabbed a man in the neck.
Which I would argue proves his propensity for exactly this kind of violence. It reinforces the state's profile of him as a violent predator. It makes the stranger danger theory much more concrete.
That is how the state sees it. But the defense wanted to argue something else entirely. The blood evidence from that stabbing went to the extent that Faust's DNA could have been inadvertently transferred to the Baker samples in the lab.
That is a massive leap. Modern forensic labs have rigorous protocols, barcoding, separate workstations, chain of custody logs. To argue that a sample jumped from one case file to another without any documentation of a breach is pure speculation. The judge was right to exclude it. The probative value of that theory is minimal compared to the prejudicial danger of confusing the jury.
All right, so I do want to jump in here and clarify one thing too that our AI hosts clearly have wrong here, and that is that the defense and the prosecution, the prosecution didn't request that the assault on February 4th be excluded. The defense did. So the defense was actually, again, and the hosts don't acknowledge this, but we'll forgive them for it because they are AI at the end of the day. What's important to understand here is that it was actually the defense who fought hard to keep this out. And again, it was also under the same theory that we heard in opening statements where they said DNA doesn't matter. We're not here to talk about DNA. And I would argue that we were here to talk about DNA and that they needed to talk about this because this is the most likely theory. This is the only theory that explains why Edrick Faust's DNA ended up on that sample or on those samples. And again, there were other unidentified DNAs on that sample, indicating that there was an issue and a potential issue with cross-contamination. And guess what? Those individuals were not in CODIS, so they did not flag, and they have been unidentified. And the state has no desire to identify who they are because it would further potentially support the idea that this was a cross-contamination hit and not actually a hit of what was found inside Tara Baker's mouth and other areas of her body. Anyways, I just want to jump in there with that clarification. Let's finish listening here.
Have rigorous protocols, barcoding, separate workstations, chain of custody logs. To argue that a sample jumped from one case file to another without any documentation of a breach is pure speculation. The judge was right to exclude it. The probative value of that theory is minimal compared to the prejudicial danger of confusing the jury with a science fiction scenario.
Is it science fiction? We heard about empty envelopes. Lieutenant Lalial testified that he sealed envelopes containing hair from the victim's body in 2001. When he opened them in court in 2026, they were empty. The hair was gone, vanished. If the chain of custody is so broken that physical evidence physically disappears.
And this is a significant fact. I want to jump in here right now because this is something that is extremely significant in understanding why the likelihood of contamination is high. The hair missing from these envelopes is just an example of the careless nature in the way, the careless way that this evidence was handled. And that is very, very significant when you're dealing with tests that are very sensitive and that are highly likely to pick up contamination. Because if in those conditions, the evidence must be handled pristinely. It must be handled very controlled, and it must be handled in a way that limits or eliminates the possibility of contamination. And again, given the fact that this evidence was collected 24 years ago, and I think like 15 years before true allele even existed. You can't say that. And again, without the defense having called experts to inform the jury of these things and to have helped the jury understand these things, that's how we end up where we end up and where we're at today, which is Edrick Faust in prison, convicted for a crime that I don't think he committed. Anyways, let's get back to the story.
Court in 2026, they were empty. The hair was gone, vanished. If the chain of custody is so broken that physical evidence physically disappears, is it really a leap to suggest cross-contamination occurred in a busy lab in 2001? Contrast that with the standards applied elsewhere. The state relied heavily on nuclear DNA for Faust, but the mitochondrial DNA testing on the pubic hair found on the body could not exclude Chris Melton.
The missing data at a molecular level. It distinguishes between contributors in a mixture. The odds 30 octillion account for noise. You cannot contaminate a sample to that degree of specificity by accident. You might get a partial match, a low-level hit. You don't get a 30 octillion likelihood ratio from a stray molecule floating in the lab air.
Unless the sample itself is compromised at the source. But let's look at the atmosphere in that courtroom. We have to talk about the contempt charge. Day 1. Opening statements.
Defense attorney Ahmed Cruz.
Right, he was fined $1,000 in front of the jury, or at least the jury saw the sanction happen, for violating the rape shield law. He tried to imply that because Melton's DNA was there, and Melton said, sounds like she was with someone else, that it showed consciousness of guilt.
So we have to talk about this as well. And this is a great point brought up by the host. And you're going to hear the prosecutor's advocate talk about this and say, yeah, Melton or Ahmed Cruz was wrong for what he did. But the reality of the situation is for a judge to come out hot like that on day 1 and hit him with a $1,000 fine, that was a warning shot to Ahmed Cruz to say, sit down and shut up and don't you dare make a spectacle of what's going on here, and don't you dare speak too loud about what's happening in this case. And that is exactly what happened, because she was blocking things out. She was hiding behind the shield laws to keep certain information out that was going to protect another suspect in the case. And that is wrong. And Ahmed Cruz was frustrated, and he knew there was no other way to get this information in. But here's the problem, and this is my issue with his strategy. First of all, one other thing that Ahmed Cruz said, I believe it was on day 1 when he was in the contempt fight, is he said that he was there because he had to prove Chris Melton guilty, and how wrong he was in making that statement. And that perhaps maybe explains, in addition to the DNA statement and openings, exactly why he lost the case. Because he wasn't there to prove Chris Melton did it. He didn't have a burden. He was there to ask questions and ensure that the state actually had proof beyond a reasonable doubt that his client did it. And yes, part of that process was he could raise the defense that there are other suspects, because the instruction the jury was going to receive was that the state had to eliminate any and all possibilities that led to innocence. And if they didn't do that, because it was a circumstantial case, they were obligated to return a not guilty verdict. But he was not there to prosecute Chris Melton. He was there to raise doubt about the case. He was there to highlight the fact that there was no other evidence supporting his client's guilt besides DNA on 2 swabs that were alleged to have come from the victim's body, but that were collected under circumstances where the chain of custody couldn't be confirmed, that were collected 24 years ago during a time when the DNA protocols and the protocols for collecting that evidence were starkly different than what would have been called for the testing that's available today. And also, these were swabs and samples where there was originally no DNA found that was available for testing. So meaning that the amount of DNA that was ended up being testable on these swabs was so minute that it required highly sensitive testing that was potentially, if proper protocols were not followed, that it could have potentially led to contamination or cross-contamination. And again, what he should have been doing was giving them the way it happened, the way it could have happened. And he should have been figuring out how he could have put that before the jury in the most sanitized way possible and given Edrick Faust if it required him to testify, so be it. But to say Edrick Faust DNA crossed that lab twice. It crossed that lab during the investigatory phase. It crossed that lab once he was convicted and he had to send his DNA into CODIS. And this is a lab that lost samples of hair. This is a lab that lost fingerprints. This is a lab that slides were opened and destroyed and had to be put back together. This is a lab where those very slides fell apart in front of the jury. And with that type of evidence handling and those type of issues in a very sensitive test and no other corroborating evidence, how in the world could a jury ever come and say, this is proof beyond a reasonable doubt? Instead, what we got was the Chris Melton trial. And Ahmed Cruz fell into the trap that the prosecutors laid and took on a burden that he never had. And they went ahead and gladly put it over and burden shifted in their closing argument. And yes, I'm going to tell you, Ahmed Cruz is a gifted orator. He gave a very good closing argument. But what he couldn't get away from, what he couldn't hide from, what he couldn't explain away because he didn't give himself the opportunity to do it, because he didn't put it on, and he tried to keep that very evidence out, is he couldn't explain why the DNA would have ever been in Tara Baker's body. And the first step in doing that was to say it never was. Edrick Faust's DNA was on a swab that was supposed to have come from Tara Baker's body. And there's a huge, huge difference between those two. And it is the prosecution's obligation to prove that swab and the contents of that swab came from Tara Baker's body and did so in a way that no other evidence or no other contamination could have occurred in that process. And they couldn't do that. And they still can't do that right now. Anyways, let's jump back to the process. Let's jump back. But for those of you out there wondering, when you think of it in this light, there's only one verdict. There's only one verdict. And unfortunately, Edrick Faust is sitting in prison tonight, sitting in a jail tonight. And that's very sad. It's very, very sad. Anyways, let's take a listen and continue listening.
Rape shield law. He tried to imply that because Melton's DNA was there, and Melton said, sounds like she was with someone else, that it showed consciousness of guilt.
It was a clear violation of backdoor evidence without filing the proper motions. The judge has to maintain procedural fairness.
I understand the legal reasoning, but think about the psychological impact on the jury. They see the defense attorney get slapped down by the judge in the first hour of the trial for pursuing the Chris Melton lead. It signals, this guy isn't playing by the rules. This guy is desperate. It undermines the defense's credibility before they've asked a single question. It frames the defense's entire case as tricks rather than valid inquiry into reasonable doubt.
Or it shows the jury that the court takes the law seriously. The defense's strategy was aggressive. They wanted to put Chris Melton on trial. They attacked his character. The fact that he was flirting with women a week after the murder, that he went to a concert instead of the vigil.
And those are valid behavioral markers if we are looking for a suspect. It's okay. Just tell me so I can explain it. She needed him clear so she could nail Faust. That isn't finding the truth, that's constructing a case. A witness with zero credibility. A woman who had suffered multiple strokes and admitted her memory was shot. A woman who initially said Faust just hit her, but then, jail helps me remember things. That was his actual quote on the stand. He's a federal prisoner looking for a sentence reduction. If that is a corroboration for the DNA, it actually weakens the case. It looks like the state was desperate to pile on anything they could find because they knew the physical evidence. The hair, the footprints, just wasn't there.
The witnesses are not the foundation. They are the mortar. The foundation is the science. You have a man, Faust, who lived 500 feet away. He had no alibi. He denied ever being
algorithm to understand. If Faust struggled with her, where is his hair?
Why is the only hair found consistent with the boyfriend or other Caucasians? The jurors, they stopped asking about the hair. They stopped asking why the boyfriend was given a pass on his own unrefuted DNA in the victim's rectum because of a theory about gravity. Ultimately, my position is that a calculator shouldn't matter more than the totality of the circumstances.
I don't think they stopped thinking. They weighed the probabilities. What is more likely? That a massive conspiracy of contamination, police coaching, and lab errors framed a neighbor, or that the neighbor with the history of stabbing people saw a window of opportunity and took it. The defense's theory requires a perfect storm of incompetence and malice. The prosecution's theory requires only that the science is accurate. Justice delayed is not justice denied. For 23 years, Tara Baker's family waited. The investigation wasn't perfect. No 23-year-old investigation is. But the central fact remains unassailable. Edrick Faust was there. His biological signature was on the victim.
The system failed to preserve the integrity of the case. Empty envelopes, coach witnesses, lost window screens, and then asked the jury to trust the result anyway. The jury may have reached a verdict, but I am not convinced they reached the truth. And in doing so, they may have let the answers to the Caucasian hair mystery and the locked room stay buried forever.
That is the burden of our system. We asked 12 people to make a choice based on the evidence presented. In Georgia versus Faust, they chose the certainty of DNA over the doubts of procedure. But a tragedy, indisputably, is the death of Tara Baker. That is the one fact we can all absolutely agree on. Thank you for listening to the debate.
All right, so that is the debate, and like I said, it is. These are things that we will produce here using the notebook LM. It's not perfect, as you can see there, but it's something that you can come in and you can, if you're a member, you can come in and listen to that again. It's available in the notebook. So are several presentations, like we have the single pillar here. We'll take a look at that, and that talks about the proof and the charges, and what led to, and it goes over the case here deeper, talking about the DNA. And again, these are important factors of what I'm showing you here, and we're bringing this up here because it's very, very important to understand that in 2001, all right, in 2001, the samples were negative of seminal fluid and sperm, and there was nothing to test. And then, and again, these are important because of these charges right here. I can't say them online, but because of these charges right here. And then in 2024, they find trace amounts of male DNA, okay? And they claim they didn't test it. They say, well, no, there was no test for sperm, but it turns out they did test. In 2001, they tested. So what we know is that whatever was found on there was not sperm. It was trace DNA. It was DNA that was from, that was like potentially skin cells or epithelial cells, or maybe a little bit of blood or whatever, or the type of DNA that can float around a lab that doesn't follow strong protocols to prevent contamination. And that's the problem. And maybe, one might say, well, maybe Melton's was. Where's the problem? Melton's DNA had no reason to be in that lab, other than if it was on the swabs. So it's actually worse for Melton to have his DNA on there, whereas Faust had another reason why his DNA was crossing through the labs. Now, it's also, they also had Melton's sample, so it's possible, but that, his could have been the source of contamination. But the reality is Melton isn't charged right now. Faust was. And my position would be no one should have been charged in this case with the evidence that exists. Not the way it is right here. So looking at this label versus science, this slide's talking about oral swab B, the false match, oral swab A, the Melton match, and how they're switched up, how they are moved from negative for vaginal cells and positive for saliva, and then they switch it up and say that the swab A was the vaginal cells, and saliva. Again, you have to remember, these are subjective things that they send them to a certain lab and they say, this is what we're looking for. And then it happens. And the fact that, again, with these minute, very small amounts of DNA, and suddenly they're all aligning themselves in the direction that the prosecution is going, and we have the investigator on tape saying that she's got one guy in her crosshairs, that she wants she wants one of the suspects to change their testimony or change their statement. Not because there's any reason to do so, other than she needs that person out of her way so she can charge Mr. Faust. That is disturbing, especially when Mr. Faust has no other evidence linking him to this crime besides that DNA. And that's a big, big problem. And this chart right here shows you that oral cavity DNA is 24 hours, vaginal cavity DNA is 7 days, and that is why it was such a big deal to move Melton's to here and make sure it didn't show up here, okay? And that is a convenient alignment that should not be ignored and cannot be ignored and should have absolutely mattered to this jury. Now, the only other piece of evidence that exists against Faust was his proximity to the crime and the fact that he lived 585 feet away. But there's no prints, there's no footprints, there's no signs of forced entry, and that is significant. The lack of forced entry means, how do you explain why? And again, this is the part that everyone must understand. We have a case where the prosecution says, I have no idea how he got in. We have a case that suggests that Tara Baker had just gotten out of the shower. That was testified to, that her hair was still wet and that she was going through her morning routine. So then you have to ask yourself, how and why would she answer the door and let that man in? Why would she have ever let Faust in her house? She wouldn't have, which means the attacker came from within. Why the jury didn't see this, I don't know. Why most of the viewers haven't seen this as a significant fact, I don't know. But it is a significant fact, because without the way of entry, there's no valid explanation for why Faust would have ever been allowed in to do what he did. And the fact that she'd just gotten out of the shower makes it all the more likely that she's going over to the door and letting some strange man in that she's never met before so that he can do what they allege that he did. Look at the defensive wounds. Dr. Falzone documents that there are defensive wounds on her attacker, meaning there was a struggle, meaning there should have been DNA found in other places. There should have been hair found. This is a man with a small afro, meaning there should have been hair, African-American hair, found in that apartment. Not one hair was found. How a jury could convict with this fact alone is really unexplainable. The weapon that's supposedly held by the killer is a knife that was burned in the fire but still had DNA on it. The only DNA on that knife is Tara Baker. Now, that means, of course, that if Chris Melton was the individual, his DNA was also not found on there either. But that is a significant fact. It's a high contact encounter. There's no DNA left on the tool. Now, some might say, well, he cleaned it off, and maybe that's what happened. But still, that is still a significant fact, that these are all areas that a man who's in that apartment for an extended period of time, he's doing a highly violent, highly personal crime, his DNA should have at least been somewhere besides minute amounts that were never detected for 24 years, and then suddenly end up on a swab that requires the use of highly sensitive DNA testing. Okay? Like, think about that for a minute. The ligature, Tara Baker's DNA is the only one on it. The sensitivity cuts both ways. So the garbage in, garbage out theory. Faust commits assault on Baxter Street. Blood is collected. Evidence arrives at the GBI Decatur lab on February 8th. January to March, Jennifer Corsi processes Baker's evidence in the same lab section. okay? In the same lab section. The risk, 2024 True Allele software detects microscopic trace amounts. If it finds 23-year-old DNA, it also finds 23-year-old contamination, okay? It is so sensitive. And again, remember, no DNA. It's so sensitive that it's finding minute traces of DNA. DNA that was never detectable in 2001, okay? You have to sit with that for a minute. You have to understand how DNA works, and many people don't. But this DNA was probably some of the most unreliable DNA that you could rely upon if the collection wasn't pristine, if the chain of custody wasn't pristine. The cleared boyfriend, let's look at this. They find a DNA found in the rectal swab 2B in oral vaginal mix. Inconsistent stories. First he says it was 10 days, then he says it's 6 days. He's flirting with people 7 days after, and he skips the vigil. And you've got Agent Bigham saying, I need to separate Chris Melton's DNA from the bad guy's DNA, telling you right away that she's expressing bias. And again, you put all of that in there. No sperm, wrong hair color, no fingerprints, no weapon, lab contamination risk, alibi witnesses, and all you have is DNA. All you have is a DNA result on a swab to which is really not a reliable sample and a reliable result because it's not backed up by anything else. And again, what it came down to is the 1 in 800 quadrillion. That's what this jury convicted on, and that's the scary part of it. But this is just, like I said, this is an example of what you will find on our site here, or in the notebook. Now, the other thing that you will find, and this is actually something that I think is extremely helpful, and it's a brain map. And I'll show you how this works. So you take this, say the case overview, and you say, okay, you click in here and it gives you the different factors. Victim Tara Baker, incident date, defendant Edrick Faust, a verdict on all 12 counts. You go in and you say, okay, we just clicked on it. So now it's going to take it into the chat and it's going to discuss what these sources say about the prosecution's strategy in the larger context of Tara Baker's trial or murder trial. So here it is. And you can go in and see this. And what I want you to know is no one else sees your chat when you're in here. So this chat is specific to you as you're viewing and looking at things. But as you go through, you can use that mind map. You can click in and it's going to click into all the different aspects. And here we have some information that comes out. So the prosecution's playbook, preemptive concession. They knew their case had massive physical gaps. No fingerprints, no African-American hairs found on the victim, no forced entry, missing evidence like the window frame. Prosecutor Baldwin did something tactically smart in his opening statement. He admitted the weaknesses up front. He looked at the jury and admitted. The DNA fortress. The prosecution's entire case lived and died on probabilistic genotyping. They didn't just say they had a match. They brought in a GBI analyst like Zacharias Sims and Ashley Hinkle to drop astronomical numbers in the science pivot. The state had a massive problem, and essentially that was Chris Melton's DNA being there. Procedural starvation, and this is where the experience of the prosecutors absolutely outplayed Ahmed Cruz. They procedurally set up traps for Mr. Cruz that he walked right into, and they shut him down. And their kind of a finale was when he goes to start his case, and they literally, in what I thought was one of the most blatant, organized assaults on Mr. Cruz in the entire trial, was when the judge, there was a coordinated motions drop on him that the judge found, boom, 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 and soon he had nothing to call. And he was completely unprepared, and they did it to him when his wife's hospitalized, when he's coming in. Again, it's not an excuse. He should have been prepared. This is a trial where he's got a client whose life is on the line. There's no excuses. And, but this is what they were doing. They were playing so damn dirty. Okay. And again, Mr. Cruz should have not had to worry about having to overcome blatant unfairness. It should have been a situation where he should have been able to depend on the prosecution to do exactly what the prosecution claimed they were obligated to do in their closing. And that is that they are not here to hunt. They're here to follow the evidence. And that is not what they did. And it was disgusting what they did. And it was very disturbing what they did. And it's something that I think absolutely must be remedied, I hope, on appeal. But we'll see. So this is Justice AI, guys. You can get access to Justice AI if you are a member. So check it out. Consider becoming a member. Consider coming in and you can interact and talk. You can type anything in. For instance, or type a question here. Explain how could have gotten on the samples through cross-contamination. And there we go. So now it's going through all the documentation and it's reading all the chapters and it's putting together an explanation. And you can do this. You can look up pieces of evidence. You can look up exhibits. Because we have the entire transcript of the trial in this database, you can come in and argue and debate with the AI. And look, so here's what matters. The jury never heard the cross-contamination pathway because the judge blocked it under 403, 404B, but the timeline and lab routing make it a massive issue that strikes right at the heart of the state's DNA fortress. Here's exactly how Faust could have ended up on Tara Baker's swabs without him ever stepping foot inside her apartment. So let's walk you through this. The final thing we're going to do. Tara Baker is unalived on January 19th. Her SA kit goes to the GBI, Division of Forensic Sciences, headquarters in Decatur. Forensic biologist Jennifer Corsi is actively processing those swabs in January and February 2001. 16 days after the unaliving, February 4, 2001, Edrick Faust stabs a man in the neck on Baxter Street in Athens. It's a bloody felony assault, and Faust is arrested and booked on February 8th. Where does the biological and blood evidence from a Clark County felony assault go? The exact same place. The GBI lab in Decatur, the exact same forensic biology section that was at that time actively handling Baker's swabs. A lab in disarray. This isn't a hypothetically perfectly sterile environment. This is a lab that the jury watched fall apart in open court. The GBI mislabeled 2 sets of swabs as oral, lost track of vaginal swabs completely, had empty evidence that should have contained hair, had glass slides that literally had to be taped back together and crumbled during the trial, and had evidence packages open and resealed multiple times with multiple sets of initials nobody could fully account for. Those are the chain of custody issues that these jury should have absolutely understood the impact of. The double-edged sword of new science. In 2001, Corsi tested Baker's swabs and found 0 seminal fluid, negative across the board. 23 years later, the state runs those same labs through true allele probabilistic genotyping software. GBI analyst Excurious Sims testifies that this new technology is far more sensitive than what existed in 2001. It can detect billions of a gram of trace genetic material, but sensitivity cuts both ways. Garbage in, garbage out. Even if a microscopic speck of false biological material, his blood, skin cells from processing, or touched DNA from his February 2001 stabbing case, ended up near Baker's open SA kit on a lab table, the 2001 test never would have seen it. But the 2024 True Allele software would have amplified that tiny speck, which is what it did, of contamination into a massive 1 in 30 octillion profile. The watchdog reality. The prosecution used extremely sensitive The extreme sensitivity of modern DNA testing is a sword to secure convictions on 12 counts. But the judge shielded the state from having to defend the contamination risks that come with that exact same sensitivity because Faust's other case was a prior bad act. The judge ruled the jury couldn't hear about the February 4th stabbing, meaning the defense was completely barred from showing the jury how Faust's blood arrived at the exact same lab at the exact same time. The state alleges Faust committed a brutal, bloody unaliving, yet they didn't find his fingerprints, they didn't find his DNA on the weapons, and they didn't find a single African-American hair anywhere in the apartment. The only thing connecting Faust to this crime is trace DNA on swabs that sat in a chaotic lab while his blood from a separate incident was processed in the same building. That's the contamination pathway. The system closed ranks to make sure the jury never got to evaluate. Now we're going to send a follow-up question in here. And we'll see what it says. But this is what you can do with this. You can sit here, you can have conversations, you can talk to it. You can also go through all of the things that we've created and read and study up on the case and become an expert and use it to, use it to challenge yourself, challenge your own theories, use it on your own shows if you're doing shows. If you're a member, that's what you get to do. That is the benefit that comes to you for being a supporter of this channel and this channel's mission. And like I said, it's not just this case that you will get it for. You get it for every single case we are covering. And here we go right here. You caught me. You were 100% right. You just hit one of the most brutal strategic traps of the entire trial. Yes, defense attorney Ahmad Cruz was the one fighting tooth and nail to keep Faust's prior criminal history away from the jury. The sources show Cruz filed a pretrial motion to exclude references to Faust's criminal history. On day 4, he fought to keep the February 2001 booking photo out because having a sheriff deputy introduce it implied a prior arrest. On day 8, he spent 40 minutes arguing to keep the prosecution from even using the word CODIS because it implies a prior felony. It's defense 101. If this jury hears Faust stabbed the guy in the neck just 16 days after Tara Baker was unalive, they're going to convict him on character alone. A Rule 404B exists to stop exactly that. You can't use prior bad acts to prove someone acted in conformity with them. But here's the catch-22. By fighting to keep February 2001 stabbing out of the trial to protect Faust from character bias, Cruz boxed himself out of his best defense against the DNA. And that is the sick part of this. That is why, in a case like this, it requires the prosecutors to make a decision based on the evidence in front of them and to not box in a defense attorney in the way that Cruz was boxed in this case. And that is what is something that should keep every one of you up at night. It's not right. You can't argue false blood contaminated the evidence at the GBI lab without explaining why his blood was at the GBI lab. To show the contamination pathway, Cruz would have had to open the door to the February stabbing, letting the jury know his client was a violent felon. So what did Cruz do? He abandoned the contamination fight entirely. In his opening statement, he explicitly conceded to DNA, telling the jury, the state may spend a lot of time talking about Mr. Faust's DNA. That is not an issue in this case. We, and this is the thing, we didn't come here to fight with DNA. And it is at that moment, in my opinion, the defense lost the case. Because they absolutely did come here to fight DNA. And at that particular moment, nothing else mattered. Not Chris Melton, not anything else. Because yes, that showed the fundamental misunderstanding that Mr. Cruz had when he walked in that courtroom. He was there to fight DNA. He should have been fighting DNA. And it was a fight that he could have won. Instead, Cruz built his whole defense around pointing the finger at the boyfriend, Chris Melton, and arguing that the mere presence of DNA doesn't prove burglary, R or M. So you are absolutely right to call me out. My previous answer made it sound like the judge unilaterally blocked the contamination theory to protect the state. The reality is much darker. The defense had to choose between letting the jury know how Faust was a violent felon or leaving a 1 in 30 octillion DNA match scientifically unchallenged. And they chose to keep the criminal history out, and they fell on their own sword to do so. And then you get suggestions here, as you can see. Explain why the defense conceded DNA evidence so early. You can click all of these things. So, like I said, this is something that is a perk. That is something that I use, and you will see me use on air at times. And it is but it's something that you, as a member of this channel, will get the opportunity to use as well, if you are a member. So keep that in mind. Anyways, let's jump out of the Justice AI here, and let's talk about, let's wrap this up, right? Let's talk about this case and the final wrap up, my final piece on it. I think you've heard what I've had to say throughout it. We heard the great AI debate today as they debated the case, and they went into it. It's been an hour and 21 minutes. I could go another 3 hours talking about this case, because it is one of those situations where it is so frustrating just to see what happened in the trial. And there's so much, from what I understand. I haven't been able to get into it. I don't have access to some of the stuff I think that others have. But I've seen, by watching other people covering this and cover the case and cover what happened, that there were a lot of things that were not allowed in at the trial, that were kept out at the trial, and that add even additional components. The way jury selection was done, evidence that was known. Supposedly there were various different things that were done. There were other people that had knowledge and information on the case, some who have passed on, that you go down, it's what you call a rabbit hole. But for Mr. Faust, he isn't down a rabbit hole. He is down a nightmare. And that nightmare right now has led him to prison in Georgia. So we need to come together as a community, as a justice of the process community, much like we did for Ty Tucker, and we need to show up for a guy that nobody thought, that the prosecutors down there and the community down there, nobody thought anyone would care about Edrick Faust. But we do, because what's happening to Edrick Faust could happen to anyone. And if we're okay with it happening to Edrick Faust, then you're basically saying that you're okay with having it happen to yourself. And it's not okay, because we must hold prosecutors and police and investigators. We must hold them to a standard that holds them accountable and ensures that when the state comes a knocking and they've decided to take away the fundamental rights of freedom and liberty and happiness from a citizen, they must come and do it with proof beyond a reasonable doubt. And they didn't do that in this case. And they need to do it with a fair process. They need to do it respecting the due process rights of every defendant, and that was not done in this case. And we must stand up against that. Anyways, with that said, guys, I appreciate each and every one of you watching. I hope you've enjoyed the Justice AI aspect. Like I said, become a member, get access to it, use it, go in. You'll have hours and hours of fun, because each and every case has one. And you can go on the website and you can find the all the different cases that we've covered on there. You'll see that there is a link. If you are a member, it will take you directly there. If you're not a member, it'll be a dead link. But once you become a member, you can go in there, click that link, and it will take you right back to YouTube, to the post that has the link to the notebook in it. And then you can bookmark that link to the notebook and have hours of fun. And leave me comments and leave me things. And if I get a lot of comments on this, we will do a live. And we can go in and I'll pull the notebook up and we can interact live. We can actually do question and answers and quizzes, and we'll type questions into the AI, and we'll do a live investigation and a live autopsy of the trial, and we can do all that together as justice watchers, because it's cases like these that activate us. It's why we're watching. And remember, justice always works better when we watch. Until we talk again, guys, keep watching.
never turned a single person down. The worst of charges didn't matter, he showed up in that town. They asked him how he stood beside the ones accused. He said it's not about the outcome, it's a fair process for the truth. Didn't matter rich or poor or what they'd done, he believed the Constitution covered everyone. Justice is a process, not a verdict, not a deal. Every single courtroom make them prove that what they feel. We don't look away, we don't let them close the door. This is what he built us for. Justice is a process, and we're watching, and we're watching. Coffee shop and paperwork, he kept on teaching constitutional rights that they said he shouldn't be preaching. 12 years old, I sat behind my father, watched the system try to break the only man that mattered. He said the law belongs to everyone who needs it, not just the ones with power, money, those who seized it. Justice is a process, not a verdict, not a deal. Every single courtroom make them prove that what they feel. We don't look away, we don't let him close the door. This is what he built us for. Justice is a process, and we're watching, and we're watching. They convicted him for caring, for teaching from a coffee shop. They feared the world he built, but the world he built won't stop. Justice is a process, not a verdict, not a deal. Every single courtroom make them prove that what they feel. We don't look away, we don't let them close the door.